Good day everyone. Today we're going to talk about Recto Law, also known as Article 1484 of the Civil Code of the Philippines. This law protects buyers who purchase personal property like appliances, phones, or vehicles on installment. In simple terms, it prevents buyers from being abused or losing too much when they can complete their payments. The main goal of the Recto Law is to protect buyers in installment sales. Here's the situation. Imagine you buy a motorcycle on installment. You've already paid half the total price, but you suddenly lose your job and you can pay the rest. Without Recto Law, the seller could take back the motorcycle and still make you pay the remaining balance, which is unfair. But thanks to Recto Law, this can't happen. It protects you from suffering double loss, meaning you won't lose both the item and your money. Now let's talk about what the seller can do if the buyer fails to pay. Under Recto Law, the seller can choose only one of the following remedies. One is exact fulfillment. This means the seller can demand payment for the unpaid installments. Two is to cancel the sale, also called as rescission. The seller cancels the contract and takes the item back. The money the buyer already paid may be kept as a liquidated damages. Foreclosing the chattel mortgage can also be a remedy. If the item is under chattel mortgage, meaning it's used as security for the loan, the seller can foreclose and sell them. However, if the sale doesn't fully cover the unpaid price, the seller cannot sue the buyer for the remaining balance. So, when does the Recto Law apply? It applies only to personal property or movable things like gadgets, vehicles, or appliances. It does not apply to real estate or land. It also applies only to installment sales. That means when the buyer is paying over time. If the buyer paid in full from the beginning, Recto Law doesn't apply.
There are four requisites of the Recto Law. First, it involves personal property. The law applies to movable items like vehicles, appliances, and not a real estate. Take note of that. Second, the price is paid in installments. So basically, the payment isn't a one-time deal but spread out over time. Third, the buyer has missed at least 2 installments. This shows a significant issue with the payment agreement. Fourth, and the last requisite is a chattel mortgage was signed. Meaning, when we say the chattel mortgage, it is essentially a loan for personal property or movable items like what I've said earlier, like vehicles, appliances, equipments, or gadgets is used as security or collateral for the debt. And that are the requisites of the Recto Law. So let's tackle the difference of the Recto Law and the Maceda Law. The Recto Law pertains to personal property in contrast to Maceda Law's application to real estate. The Recto Law deals with movable goods bought on time, and its scope is limited to chattel mortgages on personal items or property, while the Maceda Law deals with immovable property, which covers the real property contracts. So, what are they? The immovable property. Those are land, houses, condominium, or other real estate. So, I hope you gather the difference of the Maceda Law and the Recto Law. But don't worry, we will be discussing more about the Maceda Law.
Republic Act No. 6552 or the Maceda Law, an act to provide protection for the real estate buyers on installment payments. In Section 1, it states that this act shall be known as the Realty Installment Buyer Act and approved on August 26, 1972 as the protection for the real property owners from inequitable conditions imposed on sale transactions that involve real estate purchases. In Section 2, it states that this is a public policy as a protection for the buyers against unfair and unjustifiable conditions in their contracts in buying properties. And in Section 3, it states that all transaction that involves installment payments, such as condominiums, excluding industrial lots and commercial buildings, and the buyer has paid for at least 2 years, then he is entitled for the following rights. First is the buyer can pay the unpaid installment payments without additional interest within the grace period of 1 month for every 1 year of the installment payments made. And second, if there is a cancellation of the contract, then the buyer is entitled for a refund of the cash paid. And this refund is equivalent of 50% of the total payments made. And after 5 years of installments, then there is an additional 5% per year added. And this cancellation is effective 30 days after the buyer receives the notice of cancellation or demand for rescission. And additionally, the refund must not exceed 90% of the total payments made by the buyer.
Now, let's talk about the Section 4 of Maceda Law. This applies to installment buying of real estate under the Maceda Law. If you've paid less than 2 years of installment and miss a due date, the seller must give you a grace period of at least 60 days to catch up. However, if that 60-day grace period expires and you still haven't paid, the seller can cancel the contract, but it's not immediate. You first need to receive a notice of cancellation or a demand for rescission through a notarial act. Only after 30 days from when you receive that notice does the contract officially get cancelled. So, those notices are crucial for you to show or to know your standing. Next is Section 5 of the Maceda Law, which gives buyers important rights. It stated that under Section 3 and 4, even if you've missed payments, you have options before the actual cancellation. You can sell your rights to the property to someone else, essentially transferring your stake. Or you can reinstate your contract by paying all overdue amounts during the grace period. And to make these actions official and legally binding, the law requires a deed of sale or assignment to be executed through a notarial act. This means it needed to be formalized by a notary public. This ensures the transaction is properly documented and recognized. Next, we will be focusing on Section 6 of the Maceda Law, which grants significant rights to real estate installment buyers. This provision explicitly states that the buyer possesses the unequivocal right to prepay any outstanding installment or the entire remaining balance of the purchase price at any time without incurring any interest charges. This clause provides considerable financial advantage to the buyers, enabling them to potentially reduce their overall cost and shorten the payment period without penalty. Furthermore, Section 6 mandates that upon full payment of the purchase price, the buyer is entitled to have such payment officially annotated on the certificate of the title covering the property. This annotation serves as a crucial legal record, formally recognizing the buyer's complete fulfillment of their financial obligation and solidifying their claim to the property. It enhances transparency and provides irrefutable evidence of ownership. Next is Section 7, 8, and 9 of the Maceda Law. Section 7 stated that any stipulation in contracts entered after this Act's approval that contradicts Section 3, 4, 5, and 6 shall be null and void. This provision establishes the mandatory nature of the preceding sections, preventing developers from circumventing the rights granted to the installment buyers through contrary contractual terms. It underscores the protective intent of the law, and Section 8 addresses the principle of separability. It clearly states that if any provision of this Act is held invalid or unconstitutional, no other provision shall be affected thereby. This ensures that the remainder of the Maceda Law remains in full force and effect, safeguarding its overall objective, even if specific parts are challenged. Next is Section 9, dictates the effective of the Act. It simply states that this Act shall take effect upon its approval. This is a standard provision indicating when the law officially comes into force and becomes legally binding.
Let me introduce to you the Condominium Law. Republic Act Number 4726, also known as the Condominium Act. It was published on June 18, 1986. It is an act to define condominium, establish requirements for its creation, and govern its incidents. Section 1 of this act. The short title of this act shall be the Condominium Act. Section 2. What a condominium actually is. A condominium represents an interest in real property that consists of both and separate interest in an individual unit and an undivided interest in the land or common areas. Essentially, when someone owns a condominium, they have a legal right or claim to their own personal unit within the building, of course. However, there are certain shared spaces like hallways, roofs, and other common areas that are not individually owned but are shared equally by all owners. The title to these common areas, including the land itself, is typically held by a condominium corporation. This means that everyone who owns a unit in the building is automatically a member or shareholder of the corporation. The amount of ownership of share in the corporation depends on the size of their unit compared to others in the building. The real right in a condominium may not be just ownership. It can also involve other types of interest in the property depending on the situation. Section 3 in the Condominium Act. Several key terms are defined and used. First is the condominium. As explained in the previous section, it is an interest in real property where ownership consists of both a private, separate unit and an undivided share in the common areas. Next one is unit. A unit refers to a part of the condominium that is intended for independent use or ownership. This can include one or more rooms or spaces within the building that are privately owned by an individual. Next is project. A project refers to the entire place or land along with all the buildings on it, which will be divided into individual condominium units. Next one is common areas. The common areas of a condominium include the entire project, except for the individual units that are separately owned. These areas are shared by all owners, such as hallways, staircase, elevators, and recreational spaces. Lastly is the to divide. To divide means to transfer ownership of one or more condominium units, but not the entire project. This typically involves splitting of the ownership of the property into separate transferable units. Section 4. The provision of this act apply to properties that are divided or are to be divided into condominium, but only if they are officially registered with the Register of Deeds of the province and recorded under the Land Registration or Cadastral Act. The property must also have an enabling Master of Deed which must contain, among other things, the following details: description of the land, a clear description of the land of which the building is situated. Description of the buildings, information on the numbers of floors, basements, individual units, and any attached accessories of features of the building. Description of common areas, details on the shared or common areas of the property that all owners use, such as hallways, lobbies, and recreational spaces. Next is statement of ownership, a declaration of the exact nature of the interest or ownership that the purchaser acquires in their unit and the common areas. This includes a statement that the common areas and any appurtenant interest will be owned by a condominium corporation. Next is statement of intended use, a statement specifying the purpose for which the buildings and units are intended, such as residential or commercial use. It will also outline any restrictions on the use of the units, including the activities are prohibited. Certificate from the landowner. If the person signing the master deed is not the official landowner, the actual landowner must provide a certificate of confirming their ownership. Additionally, anyone who has a legal claim on the property, such as through a mortgage or lien, must also give written consent. Along with the master deed, the following plans must be attached as an integral parts of the deed: Survey plan. A survey plan of the land included in the project unless one has already been filed. Floor plan. A simple floor plan of the buildings must be included, showing the location, size, and the layout of each unit. Finally, the master deed can be changed or cancelled, but only if the owners and anyone with a legal claim on the property agree. Any changes must also be officially registered until such changes occur. The law continues to apply to the property. When a condo unit is sold like an apartment, office, or store, the buyer also gets a share of the common areas. If the common areas are owned by a condo corporation, the buyer must also get the seller's shares or membership in that corporation. If the common areas are directly owned by the unit owners, only Filipinos or companies that are at least 60% Filipino-owned can buy a unit. A foreigner can only get a unit the way through inheritance. For condo corporations, foreign ownership must stay within the 40% legal limit. Section 6. Unless stated otherwise in the master deed or declaration of restriction, the following apply. Owners only have ownership of the interior surfaces like walls, floors, ceilings, windows, doors of their unit. They can modify the interior, but if the unit becomes uninhabitable, this right ends. Each unit comes with an exclusive right to use the airspace within its boundaries, but this right ends if the unit is destroyed and becomes unlivable. All unit owners shares equal ownership of the common areas. Each unit has a non-exclusive right to pass through and be supported by the common areas, which are legally subject to this use. Owners can paint, tile, or decorate the interior surface of their unit within its boundaries. Owners can mortgage or encumber their unit, but any debt is their responsibility and doesn't affect other owners. Owners can sell their unit unless the master deed requires offering it to the other owners first. Section 7. The common areas in the condominium project must remain jointly owned by all unit owners. These areas cannot be divided, sold separately, or subjected to judicial partition. Section 8. In a condominium project with multiple unit owners, one or more owners may petition the court to sell the entire project or property and divide the proceeds based on each owner's share in the common areas. However, a sale may only be allowed under the following condition. One is unrepaired damage. A major portion of the project is damaged or destroyed and remains unrepaired for at least 3 years. Untenantable units. At least half of the units are untenantable, and owners representing more than 30% of the common areas oppose repair. Next is obsolete property. The building is over 50 years old, absolute, too costly to repair, and more than 50% of the common area owners oppose repair. Expropriation. A major part has been taken for public use and either the project is no longer viable, or more than 70% of common area owners oppose continuing the condominium setup. Governing rules allow it. The condominium's official rules allow a sale under specific conditions which are met and properly registered under this act. Section 9. Before selling condo unit, the owner must register a declaration of restrictions. It sets rules of all owners must follow and is recorded with the Register of Deeds. The declaration must name who will manage the condo and include basic rules for voting, meetings, and operations. For the management body, it can enforce the rules in the Declaration of Restrictions. It must maintain insurance for risks like fire, liability, and workers' compensation and bond its members. It handles maintenance, utilities, gardening, and other services for common areas, and can hire necessary personnel and professional. It manages the purchase of materials and supplies needed for the common areas. It handles payment of taxes, special assessment, and any other entire project or common areas. It oversees the reconstruction of any damaged or destroyed parts of the project. It defines how its powers can be delegated. It allows officers and agents to enter any unit when needed for maintenance or reconstruction. It gives the management body the power to sell the entire project for the benefit of all owners if authorized under Section 8 of the Act, and this power is binding to all owners, even if they don't agree to the restrictions. For the amendments, the declaration must explain how to change the rules, usually needing majority approval from owners. For the audit, there should be a rule requiring independent audits of the condo finances to ensure honesty and transparency. For the assessments, of course, management can charge fees to owners for building expenses based on how much of the property they own. Next is liens. It can say that unpaid dues may be lower in priority than other debts like mortgage. For the partition or dissolution, the declaration may also set extra conditions for ending the condominium setup, such as needing to rebuild by a deadline, damage beyond a certain level, or a decision by arbitration. The contents of the declaration may differ depending on the project and what's in the master deed.
So the Section 10 of the Condominium Act basically says that if the common areas like hallways, pools in a condo building are owned by a condominium corporation, then the corporation is in charge of managing the whole building. This corporation's main job is to hold the common areas, manage the condo project, and do other things needed to make this happen. The rules of this corporation in its articles and of course its bylaws must follow the Condominium Act and the specific rules set for that condo building in the master deed and the restrictions. The Section 11 of the Republic Act 4726 means that even if the general corporation law has different rules about how long a corporation can exist, for a condominium corporation, its existence is tied directly to the lifespan of the condo building it manages. So, if a condo building stands for 50 years, the corporation will also exist for 50 years. The Section 12 of the Condominium Act explains what happens to the common areas if the condominium corporation is involuntarily dissolved, meaning it's forced to shut down for legal reasons. Then the common areas like a pool or lobby will be given to the unit owners. Each owner gets a share based on their unit. But first, any money the company owes has to be paid. After that, the unit owners jointly own and manage the common areas directly. Section 13 of the Condominium Act says that the condos management company or the condominium corporation cannot be voluntarily dissolved, meaning the owners can't just decide to shut it down. As long as the condo building's master plan is still in effect, number one, major are not fixed. If the building is badly damaged and a big part of it can't be used and it hasn't been mostly fixed after years. B. Second, there is too much damage and owners don't want to rebuild it. If half or more than of the units are unlivable and more than 30% of the owners by membership or voting shares don't want to repair or rebuild it. Third, or letter C, old and outdated buildings. If the building is over 50 years old, it's outdated, and it is not making economic sense at all, and more than 50% of the owners don't want to repair, restore, remodel, or modernize it. Fourth, or letter D, building taken by government or unviable, or let's say unfeasible. If the government takes over the building or a big part of it and the condo project is no longer practical, or if more than 70% of the owners don't want to continue the condo setup after this happens. Fifth, letter E, agreed conditions are met. So if the original rules for the condo in the declaration of restrictions already listed specifically situations where the corporation could be dissolved. And those are the situations have now occurred. So those are the situations for a condominium corporation to voluntarily dissolve. And that's all for the section 13.
Section 14. A condominium corporation can be dissolved by the affirmative vote of all stakeholder members, meaning if majority of the stakeholders or unit owners agreed, they can dissolve the corporation. If all the requirements of Corporation Law Section 62 are complied. Section 15. If it does not contradict to the declaration of restriction, after the voluntary dissolution, the corporation have the power of attorney to sell all members' separate interests, or their share or own unit as a whole, and the sales received will be distributed fairly after the corporate and individual owner's creditor has been paid. Section 16. The corporation cannot sell, exchange, lease, or dispose of the common areas because it is owned and shared among the unit owners, and they can only sell it if the unit owners gives an affirmative vote to do so. Section 17. According to the bylaw of a condominium corporation, a member or unit owners must consent to sell their unit before they can pay him of his share after its liquidation or after it's sold. And all expenses gained from selling this property should be paid by the dissenting member or the unit owner. If there's a disagreement on the price, the provision of the corporate law valuation set should be followed. Section 18. After a condominium unit is sold, it should be registered on the Register of Deeds. This also gives the new owner the assurance that the condo is his. The Register of Deed will then enter and annotate the transfer of the property and will issue a condominium owner's copy of the certificate of title. This condominium owner's copy contains a brief description of the land where the condominium is built and a description of the unit and also the name and other personal info of the new owner. For the future sale of or transfer of the condominium, the owner should be accompanied by the management body approval that the transfer follows the provision of the declaration of restriction before they can register. If the condominium is under the Spanish mortgage law or the Act 334, the registration of the unit is valid if the register is accompanied by the management body certificate, and the Register of Deed keeps an original or the copy of the deed, and returns a stamped copy to the buyer. Section 19. If the master deeds allows it and all unit owners agreed for a property to be owned in common, unit owner must request to Register of Deed and surrender their condominium owner's copy to make a new title, which is called the pro indiviso co-owners. Section 20. The unit owner is responsible for the payment of the condominium assessment and any other fees. And if it's not paid, it can become a lien or a legal claim on the unit, which means that the corporation or management body can foreclose the unit. The management will file a notice of assessment to the Register of Deeds for it to be a lien. This notice must include the amount owed
and unit description, the owner's name, and it must be signed by the authorized representative of the management body. And if the owner paid assessment, the management body can revoke or remove the lien. This lien is superior to other lien, except on real property tax liens. If the owner still hasn't paid, it is treated the same as the foreclosure of mortgage of real property. Other people can bid to own the unit, even the management body. And also as benefit to the owner can buy it back within a given period. Section 21. No labor performed or service of one unit owner can be the basis of lien from the other unit owners, unless they consent or agree to it. And if it is an emergency, it is treated to be consented and will be charged on them. If work is done in common areas authorized by the management body, all unit is responsible of the cost. The unit owner can pay their fine for their lien to be removed. Section 22. If it does not contradict with the declaration of restriction, the management body can sell, buy, or dispose real property that could benefit the unit owner. For example, the management buys a CCTV for security. This will be owned by all unit owner and is charged on them individually. And if there is a transfer of unit, the new owner will inherit this share. Section 23. If the condominium is affected by condemnation or expropriation, meaning the government takes the property or part of it for public use. And if full dissolution isn't allowed under the law or the declaration of restriction, the court can first reorganize the project, second, declare which can or cannot be continued, third, declare the remaining owner, and fourth, compensation for the owner whose unit is taken. After the court decision, a court decree is issued, and the Register of Deed will enter and annotate the decree on the certificate of title.
This section says that any legal documents related to a condominium project, like a deed, declaration, or plan, should be interpreted broadly to support the smooth operation of the project. Also, if one provision or part of the document is found to be invalid, it won't affect the rest. Each part is considered independent and severable, meaning the rest can still stand and remain effective. This part talks about taxes for condominium units. When a building is divided into condo units, each unit is taxed separately. That means the owner of Unit 101 will only be taxed for their unit, not the whole building. Also, if there's unpaid tax, the government can only put a lien or a claim on that specific unit, not the entire condominium project. This section says that if there are any other laws that conflict with the Condominium Act, they are automatically amended or overruled, but only when it comes to matters related to condominiums. So even if older law says something different, the Condominium Act will still apply in condo-related issues. Finally, Section 27 simply states that this act took effect right after it was approved. No delays, no waiting review. That concludes our presentation on the final provisions of the Condominium Act. We hope we were able to explain these laws in a way that's clear, simple, and easy to understand. Thank you for your time and attention.